The Senate The Senate Committee on Health, Education, Labor, and Pensions will please come to order. I thank our nominees for being here and for your willingness to serve our country. The committee will hear from Mr. Jonathan Berry, nominated for Solicitor at the Department of Labor, DOL. If confirmed, Mr. Berry committed to refocus the Solicitor's Office on providing workers and employers with due process and ensuring DOL's actions are rooted in the law. Mr. Berry's extensive experience in labor and employment law, as well as his experience advocating for workers' rights, will be an asset to the department when confirmed. The committee is also considering Mr. Andrew Rogers, nominated to lead DOL's Wage and Hour Division. Under the Biden administration, the Wage and Hour Division struggled to curb the troubling rise of child labor and exploitation. It also pushed Biden's independent contractor policy, threatening the ability of over 27 million independent workers to choose when and where and how they want to work. As a former wage and hour official in the first Trump administration, Mr. Rogers will bring much-needed experience as the agency looks to get back on track to better protect and support American workers. We'll then hear from former Congressman Anthony Despacito, nominated for DOL Attorney General. If confirmed, I'm smiling because Mr. Despacito said in New York he could never wear a seersucker. So whenever I'm reading this, I'm thinking, oh my God. If confirmed, Congressman Despacito will be a crucial part of the president's goal to eliminate waste, fraud, and abuse. He committed to working with Congress to ensure DOL programs are being implemented effectively to identify areas for reform. Congressman Despacito's experience as a former member of Congress and as a police detective will be a valuable resource in accomplishing this mission. Lastly, the committee will consider Ms. Andrea Lucas, acting chair of the Equal Employment Opportunity Commission, who is being renominated as an EEOC commissioner. Ms. Lucas has a strong record of protecting workers from discrimination and ensuring EEOC follows the law as Congress wrote the law. Under her leadership, EEOC has a year-to-date 7% increase in monetary recoveries for workers filing discrimination complaints. If confirmed, I look forward to our continued collaboration, ensuring a safe working environment for all Americans. Thank you again for appearing. With that, we shall proceed to opening statements. And with that, Mr. Berry.
Thank you, Chairman Cassidy.
Am I supposed to, excuse me, I need to give you another introduction here. I apologize. We're joined today by Jonathan Berry, President Trump's nominee for Solicitor of Labor. If confirmed, Mr. Berry will act as the General Counsel for the Department of Labor, DOL. The Solicitor's Office ensures that the nation's labor laws are enforced by representing the Secretary and Department's agencies in all necessary litigation, both through enforcement actions and by defending DOL against lawsuits. He is an attorney with experience advancing labor policies at DOL, advocating for stronger worker protections that are not overly onerous for job creators, while pursuing litigation against policies that harm workers and employers. He is a Yale College graduate where he is a National Merit Scholar and a Columbia University School of Law grad. I look forward to hearing from you today. Thank you, sir.
Thank you very much, Chairman Cassidy, and all the members of this committee. I will start by expressing my gratitude to God for the uncountable blessings in my life, including this opportunity to serve him and our republic should the Senate confirm me. I want to thank President Donald J. Trump for putting his trust in me to return to the Department of Labor, and more importantly, to thank him for his unflagging courage on behalf of the American people over the past decade, especially in the last year against unrelenting elite hostility and multiple attempts to murder him. I want to thank Secretary Lori Chavez-DeRemer and my old friend and colleague, Deputy Secretary Keith Sonderling, for all of their support of my nomination to return to the department we love. I want to thank my team at Boyd & Gray, PLLC, for all of their love and support. My dear friend and partner, Michael, is here to represent them all. And finally, my family. My wonderful wife, Megan, is here today, allowing me to thank her personally for all that she has done to support me in over 15 years of marriage, most especially in raising up and homeschooling our precious children. Our oldest four are here, Miriam, Virginia, Simon, and Helena. And I hope the younger four have the chance to watch the stream at home with our friends and hopefully they're not setting the house on fire in our absence. I'm grateful that my brother Daniel and my sister Samantha are watching this remotely with their families. And I'm grateful that our parents, Jim and Karen Berry, could come so I can likewise thank them in person for all their sacrifices that have gone into making me who I am. My dad is an attorney, as was his father before him, my grandfather. And it was from my dad that I learned not only the value of hard work, which my mother also taught me as a successful small business owner, but that the workplace itself was charged with moral meaning. You see, employment law was always a big part of his practice, and I grew up at our dinner table hearing stories about case after case of people behaving badly in the office or on the warehouse floor. So for me, the law's influence on the world of work has always been where I've directed my attention because of my dad. That's why I've returned to the topic over and over again in my professional work, as a practicing lawyer and as someone who has tried to contribute to the policy conversation off and on for 2 decades. For me, the inflection point came in 2018 when I had the privilege to lead the department's policy office, first under Secretary Alex Acosta and then Secretary Jean Scalia. There, I focused more specifically on workers and on how to better protect them while honoring employers' essential role as job creators. I remain extremely proud of the work we were able to do, including with Keith Sonderling and my fellow nominee here, my friend Andy Rogers. In the last 5 years, my focus on the law's treatment of work has only intensified. I'm proud that my firm repeatedly challenged the previous administration's overreach, from OSHA's unlawful COVID mandate to ETA's illegal intrusion of DEI into registered apprenticeships to EBSA's encouragement of ESG under ERISA to the detriment of retirement security. I'm proud that we've represented employers against unlawful federal actions and that we've represented workers mistreated by their employers. And I've been privileged to use those experiences to refine my own thinking on employment law in hopes of contributing to a better understanding of how the law can and should build up the dignity of labor. This past Labor Day, I published my working vision statement at First Things, quote, "The overarching goal of a just policy about work should be to reinforce the nature of work as service," unquote. Work is service to God. It's service to family, to community, and to nation. And it is vindicating work as service that will be my greatest honor if confirmed as solicitor. Work can't be service, not fully, when it does not also help us serve our families and our communities. If your employer is holding back the wages you need to support those depending on you, if you're unduly risking life and limb on the job, if stewards are faithless with your retirement savings. If confirmed as solicitor, it would be my solemn responsibility to vindicate these rights and more of workers before our courts of law. And it would likewise be my responsibility to give my best possible advice to the Secretary on what the law does and does not authorize, on the good work that you, the Congress, have commissioned DOL to do. I thank you for the privilege of speaking with you today and look forward to your questions.
Thank you, Mr. Berry. Our next nominee is Andrew Rogers, President Trump's nominee to be Wage and Hour Administrator, a Maine resident. Mr. Rogers served as Chief Counsel to the Republican EEOC Acting Chair Andrea Lucas. He is currently the Acting General Counsel to the EEOC. Before joining the EEOC, he served in the Wage and Hour Division, focusing on regulations and opinion letters. He previously practiced labor and employment law at Littler Mendelson PC and Paul Hastings LLP. He received his undergraduate degree from the University of Virginia before earning his JD from the University of Virginia Law School. Please, sir, Mr. Rogers.
Thank you, Chairman Cassidy and distinguished members of the committee. Before I start, I'd like to introduce my family. I'm blessed to have my family supporting me here today, beginning with my beautiful bride, Jess, and my sweet daughters, Brooke and Emily. My mother is also here, coming quick trip in from Florida, where my father is no doubt watching online. And I'm also pleased to have my brother Ben and his daughter Addison also here in from Pennsylvania. Thank you for inviting us to appear before you today. I'm grateful for the opportunity to discuss my nomination to be the administrator of the Wage and Hour Division. As the father of 2 young daughters who will enter the workforce all too soon, I believe in a system in which they will be paid in a legally compliant way. And if they open their own business at some point, I certainly hope the government provides the resources they need to ensure the same for their workers. The Wage and Hour Division enforces some of America's most far-reaching and important statutes. These laws affect workers and employers across nearly every industry in every region, state, and territory. They also impact workers' families and loved ones. I'm both humbled and honored to have been nominated by President Trump to serve in this agency and its critical mission to promote and achieve compliance with labor standards and protect and enhance the welfare of the workforce. I would like to thank friends, mentors, far too many to mention, who have generously supported and encouraged me throughout my life and career. My interest in the law began in middle school when a neighbor filed a lawsuit to erect a fence down the middle of our shared driveway. The case was surprisingly perhaps tried to a jury in the Court of Common Pleas of Delaware County. And there, as a 6th grader, I attended the final day of the trial and marveled at the lawyer's arguments and the court's resolution of various issues. The interpretation and application of the law would evolve from a student's interest into a career, but thankfully not involving property and easements. Exposure to wage and hours issues came a few years later while working as a 16-year-old counselor in training at a camp in Maine. And although our $500 per summer plus room and board pay was far more generous than those of other camps, some groused that we were being paid less than the minimum wage. Curious how this could be, I conducted some late-night research, eventually finding Section 13 of the FLSA. And while I cannot say for certain, I suspect I was the only teenager reading the FLSA by fireside under the stars of Maine. After law school, I returned home to clerk for then Chief Judge Bartle of the Eastern District of Pennsylvania in Philadelphia. One of the many lessons I learned during those years, perhaps the most important, was applying the law correctly, getting it right, as he called it, regardless of personal agreement with the outcome. This lesson followed me to Washington, and where most of my work focused on litigation, and a significant part also involved helping employers navigate the nuances of wage and hour law, regulations, and policy. I have observed how complex wage and hour issues are navigated in the workplace, from the formulation of policies and practices to the best ways to resolve errors that arise. And while I believe most employers try to comply with the law, and that a significant number of minimum wage and overtime violations stem from an employer's sincere misunderstanding or lack of knowledge of the law, working in private practice and in government over the last 6 years has made it equally clear that some employers intentionally or recklessly disregard the law to the detriment of their workers. My public service has given me a deep appreciation for the critical role the Wage and Hour Division plays and the balanced dualism of the tools it uses. To execute its mission, Wage and Hour must develop and provide clear, consistent guidance so that employers of all sizes and means can confidently follow the law and focus on their businesses. Together, Wage and Hour's vast array of guidance lights the path for reasonable employers to pay employees as the law requires. At the same time, the Wage and Hour Division must simultaneously and rigorously enforce the law and ensure America's workers are paid the wages they earn and the other rights they are entitled to under the myriad of other statutes that the agency enforces. The strength, effectiveness, speed, and credibility of the agency's enforcement efforts are augmented when the law's requirements are clearly set forth, explained, and illustrated. The Wage and Hour Division is most effective when it is diligently pursuing and advancing both aspects of its purpose. Neither guidance nor enforcement succeeds alone, at least to its potential, when the other is de-emphasized. I'm committed to a strategic approach that emphasizes transparency, fairness, and collaboration. That includes providing clear, reliable information to workers and employers alike, using data to drive enforcement, and engaging with stakeholders to make informed policy decisions. In approaching these challenges, I've always been informed by a wide range of differing opinions. My door is always open. If confirmed, I look forward to working with this committee and with the dedicated professionals of the Department of Labor to promote economic opportunity for American workers. Thank you again, Chairman Cassidy and members of the committee. I look forward to answering your questions.
Thank you, sir. Former Representative Anthony Despacito, President Trump's nominee to be the Department of Labor Inspector General, joins us today. The representative is a former New York City police detective, bringing a wealth of law enforcement knowledge, investigative experience, and general experience. He is a graduate of Hofstra University. We look forward to hearing from you today, sir. Thank you for joining.
Thank you, Chairman Cassidy. First, I want to introduce those who have joined me here today. First, my partner in life, Cindy, my brother, Timmy, and colleagues from both local government and those who have worn the uniform in both the law enforcement and fire service. And of course, I want to say hello to my parents watching from home with my nieces, Sailor and Evie. Chairman Cassidy, members of the committee, and the American people, thank you for the opportunity to appear before you today. It is the honor of a lifetime to be nominated by President Donald J. Trump to serve as Inspector General of the United States Department of Labor. President Trump has always made one thing clear: government exists to serve the people, not itself. Under his leadership, we have witnessed record job creation, real wage growth, and a historic commitment to the American worker. He exposed the bureaucratic rot, shattered the status quo, and continues to put America first. I am proud to support his agenda, and I'm even prouder to carry that mission forward through the work of the Office of Inspector General. My life has been defined by service. I have committed my adult life to protecting Americans and upholding the public trust. That commitment started in a small village of Island Park, where I served for 25 years in the Island Park Volunteer Fire Department, including as a chief during Hurricanes Irene and Sandy. When everything else collapsed, we stood tall. No salaries, no headlines, just service. I then served over 15 years in the New York City Police Department, rising to the rank of detective. My work dismantled gangs, disarmed hundreds of criminals, and helped put violent offenders behind bars. I led the groundbreaking investigation Operation Tidal Wave, the first in NYPD history to integrate digital technology and social media to bring down 2 warring gangs. We arrested 43 criminals that morning for conspiracy to commit murder. We made neighborhoods safer. We changed how police work gets done across this great United States of America. Over the course of my service, I made nearly 700 arrests and was awarded more than 50 medals for bravery, merit, dedication, and excellence. Whether wearing the uniform of a firefighter or the famous gold shield of the NYPD detective, I never once asked about a victim's race, religion, politics, or income. I just responded to the call and helped, because that's what real public servants do. And I bring that exact same mindset with me today. I served as councilman and deputy supervisor of America's largest town, managing a nearly $500 million budget, overseeing close to 3,000 full-time union employees, and driving results across more than 20 departments. I served as a member of Congress. I sat on the Homeland Security, House Administration, and Transportation and Infrastructure committees, and chaired the Emergency Management and Technology Subcommittee. I was named one of the most bipartisan members of the 118th Congress. Throughout my career, I've built strong, respectful relationships with organized labor. I've been a union member my entire adult life and worked side by side with union leaders as both an elected councilman and member of Congress. Together, we passed pro-worker legislation, defended worker rights, and prioritized fair wages and safe conditions. Not partisan talking points, but real-world results. If confirmed, I will bring that same grit, independence, and accountability to the Department of Labor. We will go after waste, fraud, and abuse, not in press releases, but in results. We will protect the rights and safety of workers by ensuring that our laws are followed, our dollars are respected, and our programs actually serve the American people. My priorities will be clear: enforce fair wages, safeguard working conditions, confront labor trafficking and exploitation, and ensure that taxpayer money is never used to enrich fraudsters or cronies. But I won't lead from behind a desk. I've made a commitment to visit every Inspector General office across this country to hear directly from the rank and file. They are the backbone of this mission, and they deserve to be heard, empowered, and supported. I also bring a unique asset to this role: strong, trusted relationships across Capitol Hill. I understand how this institution works. I've earned the respect of colleagues on both sides of the aisle. That trust will be essential in delivering meaningful oversight and transparency, not just talk, but action. President Trump has made it clear: this is the golden age of the American worker. But we will never fully reach that promise unless we root out the inefficiencies, corruption, and bureaucratic rot that stand in the way. That's the job of the Inspector General, and you have my word that that is my mission. From the streets of a small village of Island Park to the halls of Capitol Hill, I've dedicated my life to making America safer, stronger, and more accountable. Now I'm ready to bring that same relentless focus to the Department of Labor. As an NYPD detective, I depended on my team. Color, religion, politics, economic stability, none of it mattered except getting home safe and getting the job done. I will work with each of you, Republicans, Democrats, independents, to make this office a model of integrity, independence, and effectiveness. Thank you for the opportunity to serve. I look forward to your questions and to earning your trust in the days ahead. Thank you, Chairman.
Thank you, sir. We're joined today by Andrea Lucas, President Trump's nominee for EEOC Commissioner. If confirmed, Ms. Lucas will continue her valuable work to enforce federal laws that make it illegal to discriminate against a job applicant or an employee because of the person's race, color, religion, sex, national origin, age, disability, or genetic information. Ms. Lucas is currently the EEOC's acting chair and was originally confirmed in 2020. Prior to her government service, she was a member of the Labor, Employment, and Litigation Practice Groups of Gibson, Dunn, and Crutcher, LLP, where she advised clients on a wide variety of employment-related issues. Ms. Lucas is a graduate of the University of Pennsylvania and earned her JD from the University of Virginia. We look forward to hearing from you today, ma'am. Thank you for joining us.
Thank you so much. Chairman Cassidy and members of the committee, it is an honor to appear before this committee as a nominee for a second term on the U.S. Equal Employment Opportunity Commission. I am grateful to President Trump for the trust he has placed in me since designating me in January to lead the commission and for renominating me in this spring for a second term, giving me the potential opportunity to continue to serve the American public at the EEOC, our nation's premier civil rights enforcement agency. In 2020, I was nominated by President Trump, approved by this committee, and confirmed by a vote of the U.S. Senate to serve as a first term as a member of the commission. It's been a tremendous privilege to serve on the commission for almost 5 years since then, working to advance equal employment opportunity for all Americans. During that time, I've engaged extensively with workers, employers, and related stakeholders, including members of this committee. If I have the honor of being reconfirmed, I look forward to continuing my work with this committee. To sit before you today is testament to the power of the American dream. My great-grandparents came from Italy with only second-grade education, and their son, my grandfather, entered kindergarten without knowing a word of English. And yet today, I sit before you as an attorney, as a nominee to continue to lead the agency. I am humbled to have the opportunity to serve the country that has given so much to my family in just a few generations. Today, I'm joined in person by friends and family, most importantly, my husband of almost 17 years, Brinton, who has walked alongside and supported me in every high and low of both my professional and personal life. Our two daughters, Audrey and Abby, are watching me on TV today. I joined the commission 6 months pregnant with my younger daughter, Abby, and my daughters have grown up knowing nothing but my service to our country. I work every day to be a role model to them as I balance dedication to our country and to them. I hope the sacrifices I have made on behalf of each better prepares me to serve the respective other. My daughters are joined in their virtual viewing by many family members across the country, including my mother. I wish my late father was still here to witness today's hearing, but I know that he is with me in spirit. To better understand what drives me at the EEOC, you should know about two men who strongly influenced my thoughts on employment law and civil rights. One is my father. The other is former EEOC Chair, now Supreme Court Justice Clarence Thomas, for whom my husband had the privilege of clerking. When I was a child, I watched my dad stand up for what was right in the workplace, opposing sexual harassment and speaking honestly about his faith, and he lost his job for it. My father did not regret standing up for his beliefs, but his courage cost him, and it cost my family deeply. I have experienced the immediate and long-term effects of discrimination firsthand. I see my dad's courage replicated in so many EEOC cases where workers like him stand up for their rights and pay a price. I know my work matters because I have a responsibility to those workers to zealously protect their rights. I've also seen, however, how in my dad's case, taking formal action never crossed his mind, and it wouldn't be something that he professionally or personally could have afforded. And that's true for many employees. The EEOC is charged with protecting workers. And I believe that protecting workers starts first with preventing discrimination. Of course, remedying discrimination is unquestionably central to our mission as a law enforcement agency, and I have and will continue to support robust, high-quality enforcement work. However, remedies are always a second-best option for workers. Like my father, they would have preferred for the discrimination to never have happened. I've kept these lessons from my dad's experiences in my mind during my first term in the commission and have sought to prioritize the agency's twin goals, both to remedy and prevent discrimination. With respect to Justice Thomas, I have long admired the justice and learned much from studying his time as chair of the EEOC. He came to the EEOC at just the right time to rescue the agency from disaster with his efficiency reforms, making the agency accountable to the people we serve while focusing on individual rights over group identity. That's exactly what I hope to accomplish in my continued tenure on the commission, should I have the privilege of being reconfirmed. In a 1988 essay, then Chair Thomas lamented, quote, that civil rights had become entrenched as an interest group issue rather than an issue of principle and universal significance for all individuals, end quote. As head of the EEOC, I am committed to dismantling the identity politics that have plagued our civil rights laws. If I have the privilege of serving a second term, I intend to dispel the notion that only the right sort of charging party is welcome through our doors, and instead reinforce the fundamental belief that is enshrined in the Declaration of Independence and our civil rights laws, that all people are created equal. I'm committed to ensuring equal justice under the law and to focusing on equal opportunity, merit, and colorblind equality. Through his series of landmark civil rights executive orders, President Trump has given the agency the most ambitious civil rights agenda in decades. If I have the honor of being reconfirmed, I am passionate about achieving that agenda. Thank you for your consideration. I look forward to answering your questions.
Thank you, Ms. Lucas, and I shall start. And you're kind of an incumbent, so I want to ask you a question in which you may give the challenge back to Congress. You're charged to make sure that people are not discriminated against based upon factors including genetics. I was once told to a fellow, a CEO, that when he has a candidate come to him as an applicant, he can request, and people have scoured their search history online. And so if they're searching for cystic fibrosis or for in vitro fertilization, as if to learn about it because it applies to them, the employer might make a decision not to hire on the idea that they are taking on a very expensive medical procedure, or maybe they have cystic fibrosis and they want to check. You see where I'm going with this? Yeah. Now, I think Congress is actually interested, will be interested in the coming months over issues of data brokers. So any thoughts about that, how we end up having, you tell me, you see how I'm framing this question. Do you have, how would you approach this as EEOC, or is this something that Congress needs to look at in particular on these issues?
Well, you know, we enforce GINA, the Genetic Information Non-Discrimination Act, but I will say that I have found that it is not well understood by most employers or employees, and I do think the agency needs to do more education in that space. Congress has already led in this space and made clear that you cannot discriminate based on genetic information.
Genetic information, I don't know the law. Is that defined as somehow getting a download for 23andMe? Or is that the ability to otherwise understand that somebody's genetic profile would include a propensity to a certain illness?
Any genetic information, I think, would be a part of that. So
if the child, if a couple had a child with cystic fibrosis, and they were still in fertile years and might wish to have other children, would that be considered genetic information? Because I don't want to have the expense of covering a child who might need genetic therapy?
Yes, potentially. And in fact, we authorized one of the first lawsuits that we had brought in years during my time that I voted for and was proud to support, involving, I believe it was not cystic fibrosis, I believe it was related to a blood thinning disorder, in which the company was hiring employees. In this case, in the opposite, they intentionally sought to find employees who either had this disorder or their family members did, because they wanted to be able to sell those services to them, and then they entrapped them essentially, where they would, it was really terrible. So sometimes it can go both directions, but because the company was selling services to treat those individuals, they intentionally sought to hire people like that, but then would tie them.
Sounds like you have existing tools by which to address that.
We do, but I do think we do need to do a much better job of helping people understand
If
that.
after looking at it, you decide there's more tools that Congress should give you, I think there'd be a bipartisan interest in that.
I think there's a tremendous amount of bipartisan work, and I think that it's deeply unfortunate that sometimes the agency has been viewed as universally the playground of the left. There is so much good work that we can do across the aisle to ensure, again, I think something that is really central, equal opportunity for all.
I appreciate that.
I look forward to working with you.
Congressman, man, you got like a great background for this job. I'm just telling you that. I'm sitting there thinking, all of you do, but I'm just thinking, except for your prejudice against seersucker, I just think you're a great guy.
Senator, coming from Long Island, seersucker gets a pass. It's once you get it to the 5 boroughs, there's a problem.
Obviously, you have worked with law enforcement agencies on a state and local level. And so there's going to be a common goal between what our Department of Labor would be doing with local law enforcement as regards child labor, enforcement of immigration laws that labor places. How can, with a streamlined Department of Labor, can the OIG's office work, you tell me, with state and local law enforcement to better protect our workers, our people?
Thank you for the question, Chairman. I think one of the most important things that we need to do in the Office of the Inspector General is to begin to do a couple of things. First is to actually let these state and local law enforcement agencies know exactly what resources the Office of the Inspector General offers. Second, which I think is probably equally important and I think is not being done right now, you have departments, especially in communities where the child and human trafficking is a real issue. You have giant police departments who have groups and teams set up just for this issue, and they don't even realize that the Office of the Inspector General could be a helpful resource. So I think we need to embed the Office of the Inspector General into these offices throughout the country. If we do that, we can yield real results.
Appreciate that. I had questions for you too, but I'm out of time. Instead, I will go to Senator Murray.
Thank you very much, Mr. Chairman. Let me just start by saying that on January 27, President Trump made an unprecedented and illegal move to fire 2 of the EEOC commissioners, Jocelyn Samuels and Charlotte Burrows, without cause. In the EEOC's 60-year history, the president has never fired a commissioner before their term expired. Commissioner Lucas, in 2021, you actually criticized President Biden's move to fire the former general counsel, calling the EEOC a, quote, independent agency. Now that President Trump is in charge, all the talk about the EEOC's independence has disappeared. These illegal firings are yet another example of the very long list of ways President Trump is weaponizing and making independent agencies political. In this case, the one Americans actually rely on for justice when they face discrimination at work. I led a letter to President Trump pressing him to reinstate Commissioner Samuels and Burrows. I urge my colleagues to join me in opposing any nominations to the EEOC until President Trump does that. Now, Commissioner, let me start with you on questions. Under President Trump, the EEOC has moved to dismiss cases they had previously agreed on by a majority vote to litigate. For example, the commission recently dismissed a case, Lush Cosmetics, where the EEOC itself had alleged that a manager groped an employee, asked an employee for sex, commented on employees' breasts, tried to engage employees in sexual discussions, and used sexual profanities. Commissioner Lucas, was it your decision to dismiss that case?
Thank you for the question, Senator, and for the opportunity to acknowledge my prior tweet and to note that I was wrong at that time. At the time that I indicated
I'm
that
sorry, you're referring back to the tweet about the agency?
the independence of the agency, and that's directly relevant to your question because the agency is an executive branch agency.
Okay,
but
well.
at the time that I indicated that, I was not aware of the long record that the agency had taken that position, and
Okay.
therefore it's important for, as an executive agency, us to follow the president when he directs us in an executive order to defend women's rights and to refer to individuals solely by their biological pronouns and to defend
Okay,
biological
can you
reality.
answer the question on the dismissing the case? You were acting chair of the commission when Lush Cosmetics
Yes.
Was it your decision to drop the case?
It was my decision, in consultation with our career staff, unanimous decision of the career staff, that it was impossible to both comply with the president's executive order as an executive branch agency and also zealously defend the workers who we had brought the case on behalf. We could not balance both of those interests, and therefore we gave them an opportunity to intervene, and the case proceeds forward with those workers taking the position on their own.
Well, I just want to be clear. What you're saying is that when an employee is groped, propositioned for sex, and called abject slurs at work, the EEOC will do absolutely nothing to enforce anti-discrimination laws if that employee happens to be non-binary or otherwise doesn't conform to this administration's ideas about gender. Is that correct?
Respectfully, I disagree with that conclusion, Senator. What I am saying,
I don't know what conclusion we come to other than that with that decision.
as an executive branch agency, we are complying with the executive orders. Our doors, however, are open to all workers as statutorily required. We accept all charges, regardless of how they are framed or what they are indicated. And I've made clear in repeated statements that anyone can bring a charge. They will be treated professionally, and they will
I'll
receive
just
a
say
notice
this
of
for the
right.
committee, and I just have a few seconds left. It shouldn't matter what someone's gender identity is. If they are harassed at work, they should be able to get the justice they are entitled to under the law. I just have a few seconds left. I want to ask you about, in December 2022, Congress passed my Pregnant Workers Fairness Act, which requires employers to provide reasonable accommodations to employees' limitations related to pregnancy, childbirth, or related medical conditions. Most reasonable people would agree that recovering from needed abortion care is a condition that is related to pregnancy. You voted against PFWA's implementing regulations, and you've indicated that you intend to revise those regulations to narrow the situations the law covers. Do you agree that PFWFA covers miscarriage-related accommodations?
Senator, I do agree that it covers miscarriage related because that would be related to a childbirth. My vote to disagree with the implementing regulations came as a disappointment to me. I advocated for the PWFA. I think it was an important bipartisan law.
Yes.
But it is important that the commission act with the scope of authority that Congress gave us, and we are not Congress. That rule, however, strove to displace Congress and to rewrite the rule in ways that exceeded our authority.
Commissioner Lucas, let me just say, and I am out of time, I recognize that. If it's necessary to protect a woman's health or her fertility or a fatal fetal abnormality, the law should cover that. And I find it really concerning that the commission doesn't agree with that interpretation of the law as we passed. Thank you, Mr. Chairman.
Senator Husted.
Thank you, Mr. Chairman. And Commissioner Lucas, I understand you're a native of Strongsville, Ohio, so I know the people there are very proud of your work. And so it made me think to ask you an Ohio question, because recently in the Ames versus the Ohio Department of Youth Services, the Supreme Court said on a 9-0 decision that a heterosexual employee from Ohio's Department of Youth Services alleged she was passed over for promotion and later demoted based on her sexual orientation in favor of LGBTQ plus colleagues. She sued under Title VII of the Civil Rights Act of 1964, which bars employment discrimination. As a result of that ruling by the court, how does that affect the activities of the EEOC?
Thank you so much for that question, Senator, and it's great to be with a fellow Ohioan. That is a great question, and I think it's so important to note that Ames actually just further reinforces positions, unanimous positions, that the commission has taken for 50-plus years. As you noted, that decision was 9-0, and it was written by Justice Ketanji Brown Jackson, sometimes regarded as the most liberal member of the court, and yet it is clear that it is a unanimous bedrock principle that our civil rights laws are colorblind. So I would say that it only reinforces the long-standing work the Commission has been doing. It doesn't change our work. The Commission, and I was proud to sign on to this unanimous bipartisan amicus brief in the Supreme Court on the merits of that, joined by, again, the Biden administration Civil Rights Department, that everyone on both sides understood that no matter your sex or your race, that you should be treated equally and even-handedly by our civil rights laws. So we're just going to charge further and faster forward on that long-standing principle of civil rights law following Ames.
Great. Well, thank you. I'm sure that there will be some updating of guidance and things like that from the EEOC based on that ruling. Is that correct?
We don't currently have a quorum, Senator, and we look forward to, if I have the privilege of being reconfirmed and if I have an additional colleague, so that we can have a third member of the commission, being able to move forward. But we'll continue to issue technical assistance documents, which are unanimous restatements of longstanding principles. We've already done some of that work. We released with the Department of Justice a one-pager educating individuals where DEI can lead to unlawful race or sex discrimination. The Ames decision fits perfectly into that existing document, and we issued a longer Q&A document to help employers understand their rights and responsibility in that space.
Great. Thank you. Mr. Despacito, want to quickly try to get to a couple questions for you on the issue of how we are handling labor issues regarding human trafficking and the role of illegal immigration in the workplace and how, in many cases, it is in the workplace that a lot of human trafficking is occurring. Is there a role for Department of Labor in stepping up efforts on looking at how illegal activities from people who are in this country illegally and conducting human trafficking, is there a role for you to improve our labor conditions around those issues?
Well, thank you very much for the question, Senator, for the opportunity. And I think that the Labor Office of Inspector General has a huge presence in human and child trafficking. And recently, I've been criticized for talking about President Trump's belief in that this is the golden age of the American worker. And I think that that term, golden age of the American worker, is not a Republican term or a Democrat term. Quite frankly, it should be an American term. And in order for this to be that golden age and to give the American worker fair wages, to make sure that the American worker has safe working conditions, to make sure that our own American children aren't getting tied up in this exploitation of labor trafficking, it is essential that the Office of Inspector General, like I mentioned in my remarks to the chairman, that we begin to work even harder to embed ourselves into local and state authorities, to work with our other federal partners to pinpoint locations throughout this country. It could be in communities that you represent, that unfortunately it's a small local police department that doesn't have the ability to address these issues. And that's what the Office of the Inspector General should do. And that's one of the reasons as to why in the beginning, if confirmed, I would love to travel to all the regional offices and hear from the men and women on the ground and what they're dealing with in this scope of human trafficking so that we can pinpoint resources and make this country safer for the American worker.
Great. Thank you both. Thank you, Mr. Chairman.
Thank you. Senator Baldwin.
Thank you, Mr. Chairman. Mr. Berry, your name appears on the Department of Labor chapter in Project 2025. A theme of that chapter is the role of women in the workplace. The chapter reads, just a quote, DOL should commit to honest study of the challenges for women in the world of professional work. The Women's Bureau at DOL tends towards a politicized research and engagement agenda that puts predetermined conclusions ahead of empirical study, end quote. Can you name a barrier that women face in the workplace?
Senator, thank you for the question. Thank you for the chance to talk about this. I want to start by identifying that So the chapter is not focused on that single issue. It's a broader context looking at the swath
we
of
can
labor
all,
employment issues.
we can all agree on that. I'm asking about, can you name a barrier that women face in the workplace?
Certainly, I think at times there's very real sex discrimination, for example.
Okay. What about a barrier identified by the Women's Bureau, wage inequity?
Right. So that is right. That would be downstream from a variety of issues. One of which is going to be sex discrimination.
Okay. Another from that same office, the Women's Bureau, that you say has been politicized. Do you agree that access to childcare is a barrier to work for women?
Access to childcare is absolutely an issue that a lot of women in the workplace have to deal with. It's an issue for men as well. Yes.
Congress created the Women's Bureau in 1920 to address issues women face at work. And through investigations into working conditions of women in factories, the agency helped establish the 40-hour work week and the Fair Labor Standards Act. This administration has proposed to eliminate the Women's Bureau. Do you support that?
I support whatever the administration decides on that, what President Trump supports, but that was not one of the policy proposals discussed in the chapter that I was the lead author of.
So since the administration has proposed to eliminate the Women's Bureau, you do support that? Is that what I hear?
That will be, ultimately, Senator, that's a decision as between President Trump and this Congress.
Okay. It's a simple yes or no question. He has proposed that.
Yes, and I'm
thank
prepared
you.
to support the president.
Commissioner Lucas, I want to continue in the same line of questioning of my colleague, Senator Murray. The Equal Employment Opportunities Commission is charged with enforcing laws prohibiting workplace discrimination. However, as soon as you assumed the role of acting chair, you moved to dismiss every lawsuit filed by EEOC on behalf of workers who faced discrimination on the basis of their gender identity. One of those cases you moved to dismiss was on behalf of a farm worker on a farm in Illinois. In that case, the employer refused to call the employee by her name. Coworkers exposed themselves to her. And she was subjected to groping and sexual comments while at work. No employee should have to go through that. You moved to dismiss this case. Do you think it is appropriate for someone to be harassed like this anywhere, let alone at work?
Respectfully, Senator, I appreciate your question, but the only question before me at any particular moment is whether or not I can comply with the scope of my authority under the laws entrusted to me by Congress and as an executive branch agency head, the president's directives. And the combination of
Perhaps
those
federal
things-
Supreme Court precedent in Bostock?
Certainly, and I'm delighted to have the opportunity to clarify the holding of Bostock. Bostock is unquestionably the binding precedent of the Supreme Court. It's entitled to respect as such. But
And
Bostock,
I've also read Bostock, so I don't need a lecture on that. But another case, a worker at an airport restaurant was outed by her manager and harassed by coworkers, which led to a customer using both homophobic and racist slurs against her. After reporting this offensive sex-based and race-based harassment to a manager, the employee immediately had her airport security badge taken away, and that was effectively terminating her position. Again, you moved to dismiss this case. Do you think it is appropriate for an employee to face this type of retaliation in the workplace?
again, Senator, I go back to my decision to have the agency dismiss those cases was made in consultation with career staff, unanimous support to that decision about balancing our obligations under the executive order defending
Have you
women.
directed EEOC staff to code all gender identity cases as meritless charges?
I appreciate your question, but unfortunately, I cannot answer it as it would require me to breach Title VII's confidentiality provisions and deliberative privilege and attorney-client privilege.
Senator Moody.
Thank you, Mr. Chairman, and thank you to all of you for being here today and standing ready to answer very difficult questions. But if I might just take a personal moment and say thank you for serving. It is not just a big decision to serve your country and take time away from what could be very lucrative private careers. I know your families give up a lot to help you in that process, and I'm mindful that there are some that couldn't be here and are watching at home, and I hope that they are incredibly proud of their parents today. As a mother of a school-aged child, I am also balancing those responsibilities, and the families often are our biggest support structure. So thank you so much for taking this on and being someone that I know your families are very proud of, each of you. I was reflecting in preparation for today's hearing on some of the things that we had to address over the last 4 years as states. I was the Attorney General of Florida, dealing with an administration that was picking and choosing enforcement in a way to pick and choose winners and losers, and oftentimes neglecting the most tragic of circumstances, and even those of children. As Attorney General in Florida, we realized that children were being smuggled over the border and then taken the last step of the way by the Biden administration, put into the hands of quote-unquote sponsors. Many times these sponsors were taking in dozens of children. We found when we launched a grand jury investigation that many were being placed in unspeakable conditions, not followed up with. One was sent to a strip club, one was sent to an empty lot next to shipping containers. I could go on and on. I believe the grand jury stated that they were circumstances that were not done justice by mere words. In that grand jury investigation, they also found that tens of thousands of children were lost by the federal government under the Biden administration. And when we sought to get the Biden administration to send someone to discuss with our child welfare agency that was responsible for the welfare of children within our state, they refused to do so, refused to send witnesses to the grand jury, refused to provide information to the grand jury, as they didn't see how it would serve their interests. I think you could all understand that the interests of children that are lost into trafficking and found not only in sex trafficking but labor trafficking was what we were trying to investigate. And I know that all of you are going to serve very important roles, whether in different capacities, but I would like to offer the question that anyone would like to respond. Moving forward, obviously, this is of extraordinary importance. As you can tell, many people have brought this up. You have to understand what happened in the prior administration to understand how to prevent it from happening again. But I'd like to hear from whoever would like to answer the first thing that you will do in your new role, if confirmed, to address how this happened and to prevent it from happening again.
Senator, thank you very much for that. I think one of the very most important things that can be done to remedy the situation of functionally open borders that we had in many respects in the last administration is to very vigorously enforce our employment laws. Our employment laws, vigorously enforced, can do a lot to stamp out the so-called shadow economy among employers who are seeking to look to exploit people who are in the country illegally. And that's a lot of these trafficking issues can be addressed in part through the authorities that I would be privileged to help enforce.
Yeah, Senator, thank you for the question. I think part of the Wage and Hour Division's responsibility is to enforce, as you know, the child labor elements of the Fair Labor Standards Act, and it's a very important part of every investigation. And I think the last several years have seen the increasing amount of trafficked children who are presenting forged and otherwise, fraudulent documents to be able to support child labor. And part of the work of the Wage and Hour Division is to make sure that we're enforcing the laws against employers that are intentionally really exploiting children and are not also being exploited
And
themselves.
specifically, unlike the last administration, if you were to find evidence of that, would you present that information to the state so that they might better oversee the welfare of those children?
Senator, working with other enforcement agencies and other folks that have interest in enforcing the laws of this country is definitely something the Wage and Hour Division continues to do.
Well, thank you, Senator, for the question, and thank you for your work in Florida. I think that unfortunately there are too many states and local prosecutors throughout the country that have turned a blind eye to this issue. And one of the things that I think is critically important to the Inspector General is hopefully upon confirmation is to taking a real look at what personnel and what resources are being allocated to child and human trafficking. And if it's not enough, we need to adjust it. And like I said to a couple of questions, I think the collaboration between prosecutors, whether it's on a state or a local level, and the work that you can do with local law enforcement agencies is really how to get this job done. Nobody knows their communities and who's doing what in those communities better than local cops, local investigators. And I think that the inspector generals have failed in really embedding themselves into those communities.
And I know your background with law enforcement, et cetera, but communicating with child welfare agencies of the individual states is of utmost importance.
Absolutely.
Thank you.
Senator Hessen.
Well, thank you, Chair Cassidy, and congratulations to all of the nominees, and thank you for your willingness to serve, and thank your families for supporting you. My first question is going to go to each one of you. To all of you, I want to ask you a simple question. If directed by the President to take an action that would break the law, would you follow the law or follow the President's directive? Mr. Berry.
Senator, President Trump would never ask me to violate the law.
Well, are you going to follow the law if he does instruct you, or anybody in a position above yours instructs you to break the law?
Senator, I can't answer hypotheticals like that. I can tell you that in my first time getting to serve.
All right, I'll take that as a no, which disqualifies you. Mr. Rogers.
Senator, thank you for the question. I don't think the President would ask me to violate the law, but I would follow the law.
Thank you.
Thank you for the question, Senator. I have no intention of getting a request from President Trump to violate the law, but as I've done in my entire career, I will follow the law.
Thank you. Ms. Lucas?
As the other nominees have noted, I'm confident the President would never ask me to violate the law. I've served in both the first and second Trump administration. He has never and would never ask me to do so. I'm committed to complying with the law.
I'm glad you're committed to complying with the law. I will note that the President and Mr. Vogt have refused to follow the Impoundment Control Act of 1974. He has pardoned people who were convicted of assaulting law enforcement on this campus. He is treating foreign policy as if it is his personal business, likely violating the Emoluments Clause. And this administration's failure to follow due process is a clear violation of law. So you might want to rethink the first part of your answers. Now, let me go to you, Mr. Rogers, for another question. The Wage and Hour Division field offices play a critical role in helping to ensure that workers get paid what they've earned. The Manchester, New Hampshire Wage and Hour Division office has been especially effective in this effort, recovering nearly $8 million for almost 5,600 Granite Staters in the last 5 years. Yet in March, DOJ terminated the lease for this office, the only such office in New Hampshire, effective August 31st, without any indication of whether there is a plan to continue having an office in New Hampshire. So, Mr. Rogers, if confirmed, will you commit to reviewing this action by DOJ and working with my office to keep the Manchester Wage and Hour Division office open?
Senator, thank you for the question. If I have the privilege of being confirmed, I'm happy to look into it. I don't have much insight into it now, not being in the building, but I'm happy to look into it and follow up with you.
I would look forward to that very much. This is kind of a classic DOJ thing. They terminated an office. They haven't indicated any kind of follow-up in terms of what workers in New Hampshire are supposed to do to make sure that their wages and hours are protected and that their rights are protected. And I would look forward to working with you on that. Representative Esposito, earlier this year, President Trump illegally fired the Department of Labor's Inspector General, along with several other inspectors general. Again, another example of the president not following the law. Do you support the firing of inspectors general without the president first providing the required statutory notice to Congress?
Well, thank you very much for the question, Senator. I believe, I'm not an attorney, but I believe that a court recently upheld President Trump's decision to fire the inspector generals.
Do you support his doing it without providing the required statutory notice to Congress.
I support that the American people elected President Trump to lead this country, and if President Trump decided, if I was confirmed, to dismiss me, I would understand.
Talk to me about your understanding of the role of Inspector General and the importance of independence from political influence, because that answer, the notion that you work for the president and not the American people, in an Inspector General's role, is a concerning answer, because there are Inspectors General who have worked for multiple administrations, finding fault in multiple administrations of both political parties, and that's the whole point. They're supposed to be independent. So talk to me about your understanding of the role.
Well, thank you, Senator. I'm well aware of the role of the Inspector General, and just as I have in my entire career, I plan on, if confirmed, leading the Inspector General's office without fear or favor. I plan on, just as I did as a decorated New York City detective, working under multiple administrations between Mayor Bloomberg and then Mayor de Blasio, who single-handedly tried to destroy New York City. I still went out there and did my job regardless of who the leader is. I will continue to work independently, just as I have, to do the work of the Inspector General, and that is to rid the Department of Labor of waste, fraud, and abuse.
Will you commit to continuing any open investigations that were initiated by the last Inspector General?
I can't answer that question until I see what the investigations are.
That is also concerning. Thank you, Mr. Chair.
Thank you, Mr. Chairman. Ms. Lucas, you are already cracking down on employers who discriminate against American workers in order to hire illegal immigrants as workers instead. Can you give us some examples of these anti-American national origin discrimination cases that you're working on?
Thank you so much. Well, I can't talk about confidential matters. I can talk about press matters that are public. Since 2019, the Commission has recovered almost $7 million for American workers, as recently as a $1.4 million recovery during my tenure as acting chair. And these often will entail a preference for a foreign worker at the expense of an American worker. The victims that we're recovering for are often a broad multiracial group. So we've recovered money for Black, white, and Asian workers. The fact patterns vary. A common pattern that we will see is an Hispanic preference, and it may occur in a warehouse, an agricultural business. And to be clear, the employers are often victimizing the workers that they prefer as well. They view that that the worker may be less educated about their employment rights or more vulnerable to abuse, and therefore they prefer them over the American-born or local workforce. But regardless of their motives, it's still unlawful. So we've really had a lot of success in that space, and I think we have a significant caseload to support more of that.
On that note, the EEOC has been bringing national origin discrimination cases for years to protect groups of workers. And as you said, whether they are Black, white, Asian, or another race, your predecessors rarely spoke up about what they all had in common, which is that they're American citizens. Can you walk me through some of the trends that you're seeing on that front in cases like those, and what motivates that discrimination?
Yeah, it can be found in almost every industry. How it plays out varies. I think that when you look at warehouse businesses, agricultural, manufacturing, it is often Hispanic preference, but sometimes it is another preference for foreign workers. Either way, it is often motivated either by racial bias, the assumption that a particular racial group that you're bringing in of an immigrant will be more motivated than the local white or Black workforce. And sometimes it's motivated by economic arbitrage, the sense that you'll be able to pay them less because at any point you could deport them. We've seen everything from, again, Hispanic worker preference to importing workers from the Philippines that they can, on visas, that they can, at the moment's notice, get deported, revoke their visa, or move them all over the country. We also have seen it in the tech industry in particular with preference for H-1B visa workers at the expense of, again, local workers. So it can come up in both high-skilled workforces as well as your frontline manufacturing jobs. It can also come up in terms of company towns, where instead of employing hardworking Appalachian workers that are in your local communities, you are again importing foreign workers, decimating those towns and creating kind of a captive workforce again. It's a serious problem.
I recently introduced the Restoring Biological Truth to the Workplace Act to protect workers' rights to use single-sex bathrooms and shield them from retaliation by employers when they say things like there are two sexes, male and female, which is common sense. How did the Biden EEOC encourage that type of discrimination, and how are you combating it?
I think this is a place where the Biden administration absolutely weaponized the EEOC. I think the agency has done a lot of bipartisan work in many other areas, but in gender identity, there's a tremendous amount to roll back. The agency exceeded its authority by passing a harassment guidance, which I dissented to, taking the position that essentially abolishing single-sex spaces and preventing individuals from being able to use biologically real pronouns and declaring that that would be harassment. The agency, however, does not have substantive rulemaking authority. We don't have the ability to create rules. That's Congress's rule in Title VII. My dissent, I think, was recently vindicated. A federal court vacated those portions of the harassment guidance. And we've noted that vacatur accordingly. I won't be able to formally roll back that guidance until we have a quorum. Should I have the privilege of being reconfirmed? Should we have the privilege of having an additional commissioner on the commission? But I am committed to doing that. Wherever I can lawfully comply with the executive order on defending women, I've done so. I think some of it is simply the tone of the top, making clear that it is okay to say basic biological reality. There are men and there are women, full stop.
And you agree Congress needs to do its job and make those protections permanent, that the ruling could be simply overturned by the next administration.
That's right.
Thank you. I yield back.
Senator Kim.
Thank you, Mr. Chair. Ms. Lucas, I would like to start with you. Your response to an earlier question made it sound like you don't believe that the EEOC is an independent agency. I just want to confirm your position on this.
That's correct. The EEOC is not an independent agency. And in fact, every single one of the former Democrat members that were terminated by President Trump, they know that. They know that, and so do colleagues across the decades. Since the 1970s, the EEOC's Office of Legal Counsel, as well as the Department of Justice's Legal Counsel, has held that we are an executive branch agency. In fact, to rule otherwise or to conclude otherwise would make us unconstitutional because we accepted jurisdiction over the ADEA, the Age Discrimination in Employment Act in the 1970s, and since then, the only way that could be constitutional would be for us to be an executive branch agency. We've accordingly complied with that for decades.
So I just want to ask you, in terms of your own work, has anyone from the White House or elsewhere in the executive branch urged or suggested to you or your staff to dismiss a case, take on a specific case, or decide in a certain way?
Respectfully, Senator, I cannot breach deliberative privilege or attorney-client privilege or Title VII confidentiality, so I'm unable to be responsive to your question.
So you can't say a simple no on that?
To answer your question would require me to breach the privileges.
Well, I guess maybe I'll frame it in a different way. Would that be appropriate? Would it be appropriate for the White House to tell you to take on a certain case, dismiss a certain case, or to rule in a certain way?
I can't engage in hypotheticals. I can say
Look, it's not a hypothetical because you're saying to me that you are not an independent agency. You report to who?
I report to the president.
So if the president gave you a directive, what would you do?
It would depend on what the directive was, but I report to the president.
So you report to the president, you take directive from the president?
I do take directives from the president.
Correct.
Yes.
So if the president issued a directive saying that he wants you to take on, and look, I will just say whoever the president is, because if you go through this term, it could very well be another president, you have to follow that directive.
If the president gives me a lawful directive, which I'm confident that he would do, then I would obey that directive. And I think it is entirely appropriate for the president to direct the enforcement actions of the agency.
So it's
consistent with
entirely
the law.
appropriate for a president to tell you that the president wants you to dismiss a particular case.
Again, the president directed us to comply with the law, and we're doing so.
Is it within the law for you to be able to dismiss a case?
The agency has prosecutorial discretion at all times.
Correct. So I just want to point out the damages and the challenges of what happens if you are moving away from this idea of some independence. The EEOC is founded upon this idea of protecting rights for all Americans, correct?
It is,
The civil rights for all Americans.
yes.
So there comes a problem, though, if your agency does not have credibility as being one derived from a sense of fairness and instead can come at the whim of potential coercive influence or political whim. So I just want to point out to you where I see the faults of what you're saying in terms of EEOC not being an independent agency. I think the American people will lose credibility, lose trust in the EEOC because you have a very particular role. And I wanted to be able to explain to you and the American people what the problem would arise in. You know, the fact that you are saying that the president is your boss, that you take direction from the president, and if the president tells you to dismiss a case or to go after a particular employer or to rule in a particular way, I just find that to be a dangerous place for us and our government and our democracy.
Respectfully, decades, for 30, 40 years, the agency has taken this consistent position. It's done okay in that time, and I'm confident it'll continue to do okay. But I think the American people should be delighted at the idea that President Trump is leading with an amazing vision for civil rights for all Americans, and that should thrill them. That he is, again, as many have said, seeking to restore the golden age of worker and dismantling the identity politics that have been present far too often at the EEOC.
Well, I just want to remind you that, you know, your boss is not the president, your boss is the American people, and that we swear an oath to the Constitution, not to a particular president. And I will hope that you fulfill that oath. With that, I'll yield back.
Senator Hawley.
Thank you very much, Mr. Chairman. Congratulations to the nominees. Thank you all for being here. Mr. Rogers, let me start with you. As you might know, on the 6th of May, I sent a letter to the Secretary, Ms. Chavez de Remer, on a topic that's extremely important to me and to my state, and that's illegal child labor. I relayed to the Secretary whistleblower information that I have received from an employee at Tyson Foods alleging that that individual employee had witnessed underage labor in a Tyson's plant. That same whistleblower also had information regarding other underage employees at other plants, and this is by no means an isolated incident. The New York Times even has done a comprehensive series of stories on underage illegal child labor in various poultry processing plants around the country, including Tyson Food. Now, I'll tell you why it's particularly irksome to me, because Tyson Food unceremonially closed 2 major plants in the state of Missouri after telling our workers and farmers they would remain open. They canceled contracts with our farmers, putting many of them into bankruptcy. They fired all of the workers, sending many of them into destitution. And what we learned instead is that Tyson is happy to hire and use illegal, I mean, hire is the wrong word. They're happy to use illegal child labor in their supply chains. So they're punishing Missourians, they're closing our plants, they're breaking our contracts, but they're hiring illegals and they're using child labor. So let me just ask you, are you familiar, broadly speaking, with these reports as it regards Tyson and other poultry processors?
Senator, I'm generally aware of the reports, but not the particulars that you mentioned.
Well, following my letter to the Secretary, the acting head of the department, the division that you are now nominated to fill, responded to me and said the following: protecting children against illegal child labor is one of the top priorities of the department and the Wage and Hour Division. Wage and Hour investigates every actionable complaint, tip, and referral about child labor violations, takes those allegations very seriously. He went on to say that the Wage and Hour Division is engaged, I'm quoting now, the Wage and Hour Division is engaged in ongoing investigations of Tyson Foods and its contractors under the FLSA. So here's my question for you. Should you be confirmed, will you continue WHD's open investigation of Tyson Food?
Well, Senator, I can't comment without knowing more of the details, but I certainly commit to continue to investigate offensive child labor wherever it may be.
Okay, good. And let me just ask you a little more specifically, what actions would you anticipate taking to ensure that illegal child labor is not possible in this country in the year 2025?
Well, Senator, there's a lot of ways in which the department can focus on continuing to do, as Secretary Chavez DeRemer mentioned, to double down on enforcing against oppressive child labor. And one of those ways is to use the resources that we have and to use the data that's available to drive down where those violations are most likely, take tips such as yours, and to move forward as aggressively as possible to make sure that we can eradicate unlawful child labor in this country.
I just want to emphasize to you that this issue is of the highest importance to me. I think it is absolutely unconscionable that we have child labor being used widely by these mega corporations, and I'm particularly incensed that it has happened to the detriment of Missouri workers. I don't like being lied to, and I will tell you that the CEO of Tyson Food has lied to me, and he has lied to the people of my state. And I don't like it being lied to and then having the law broken in front of my face, flouted in front of me. As a former prosecutor, it irritates me, it rankles me, it infuriates me. And I want to see some justice here. I want to see justice for the kids who are being illegally employed. And yeah, I want some justice for the Missouri workers who were tossed out in the cold because Tyson Food has chosen to found its supply chain on illegal labor and child labor. So I just want to underscore for you that this is the highest priority for me. And if you are confirmed, I'll look forward to working with you on it. I can promise you, you'll hear a lot about it from me.
I look forward to that, Senator.
Great. Mr. Berry, the Biden administration in 2023 rescinded the Trump administration's previous rule on religious exemptions for federal contractors and subcontractors, as I'm sure you're aware of. The effect of that was to strip away protections that ensured that faith-based organizations didn't have to violate their consciences in order to compete for federal contracts. My question is, does DOL plan to reinstate the implementing legal requirements for that previous rule? Will you put back in place the protections?
Senator, religious liberty, including in the practice of business and contracting, is of the utmost importance under the Constitution and my personal views. That will be, I think it's a serious issue that will have to be worked into the department's larger plans for federal contractors. But
will you advocate for it?
I will absolutely support robust protections for religious liberty.
Good. Well, I see my time's expired, and I never go over my time, Mr. Chairman. That's a joke. I'm sure the other nominees are just devastated I didn't get to ask you questions, so I'll have some more questions for you for the record. Congratulations to all of you. Thanks for your willingness to serve. Thank you, Mr. Chairman.
Senator Blunt, Rochester.
Thank you, Chairman Cassidy, and thank you to the nominees for being here. Congressman, I'd like to start with you. You shared that you're a union member and pro-worker rights. Do you support the Davis-Bacon Act?
I do.
Thank you. Mr. Rogers, I heard concerns from Delawareans about the Trump administration's commitment to the prevailing wage, and it's critical that we support fair pay for workers. If you are confirmed, will you commit to fully and fairly enforcing the Davis-Bacon Act that requires construction workers to be paid equitably on federal construction projects?
Senator, yeah, I would commit to enforcing all of the statutes, including the Davis-Bacon Act, that are within the purview of wage and hour.
Thank you so much. Commissioner Lucas, I want to turn to you. As you know, the EEOC was created as part of the Civil Rights Act in 1964, and a core part of the EEOC's mission is to advance equal opportunity for all. Do you agree with this mission, yes or no?
Absolutely.
And when it comes to protecting workers from harassment, let me ask you this. Do you think verbal and physical abuse in the workplace is wrong?
I do.
I want to kind of zero in a little bit and follow up to my colleagues' questions. On the first, in the beginning in January, the Trump administration issued an executive order attempting basically to erase trans and non-binary people from federal protections. And in the time since, the EEOC, under your leadership, has dismissed 7 lawsuits filed on behalf of trans and non-binary workers who filed these cases because they endured unwanted touching, verbal and physical abuse, and ultimately were either forced to quit or were fired. Not specific to those cases, and following up on what you said about President Trump's vision of civil rights for all people, do you believe trans people are protected under Title VII of the Civil Rights Act of 1964? Basically, are they included, trans and non-binary people, as part of your, the vision that you said the president has for civil rights?
Thank you for that question, Senator. As I mentioned in response to one of the other senators, Bostock is the binding precedent of the Supreme Court. It should be accorded respect as such, and Bostock did clearly hold that discriminating against someone on the basis of sex included firing an individual who was transgender or based on their sexual orientation.
So, meaning they are part of all people that should be protected.
To the extent that someone has been terminated based on their transgender status, they are protected by Bostock's interpretation of Title VII.
I think, again, part of the concern is that we have seen in reports that under your leadership, the EEOC staff have been instructed to code discrimination charges related to gender identity as meritless, which would all but ensure that these cases won't be resolved. Are these reports accurate?
I respect your question, but unfortunately, I can't speak to our investigative processes that would require me to breach Title VII's confidentiality provisions and deliberative privilege.
You haven't spoken to them, but other employees have. And if this is true, this is a major problem. To carve out any group, including trans people or non-binary individuals, would be antithetical to the mission. So as I look at this record, in just the short time, lawsuits have been dismissed, resources have been erased on your website for LGBTQ plus workers. People have been intimidated, law firms that are perceived as advancing diversity, equity, and inclusion. And all of this has just been in the short time. And that's without your full authority of being confirmed chair. This causes a lot of concern. I think there are a lot of people in this country that from day one, the executive order, we talk about being colorblind, but people are feeling erased. And so I hope that if you are confirmed, I urge you to be mindful of your mandate to advance the promises of equal opportunity for every American, not just those that are deemed worthy by this administration. With that, I yield back, Mr. Chairman.
Thank you, Mr. Chair. And Senator Murkowski, I think I owe you one there. Appreciate all of your public service. Let me start with you, Mr. Berry. In Colorado, we've got numerous employers who rely on H-2A and H-2B visas. Our strong agricultural economy relies on the H-2A program to make sure that people have fresh, safe food, quality food on their tables. Rocky Ford cantaloupes are known nationwide. Certainly, they're not available nationwide, but Palisade peaches are a rival to any Georgia peach. If Senator Ossoff was here, I would say it out loud. In the same way, our powerhouse outdoor recreational economy relies on the H-2B program to operate our ski areas and a number of different outdoor recreational venues. So as part of Project 2025, you helped write that chapter on labor that called for the elimination of both of these programs. I don't know how we can find the domestic labor to fill these roles. If you ask any farmer, we're offering $22 an hour to people come pick peaches, and we cannot get the labor to do that. Both these programs are not perfect. I'm not saying they couldn't be improved, but they provide a much-needed and necessary workforce. And these visa holders contribute to our economy and then return home to their countries. This is not the problem that the president campaigned on. So if confirmed, are you going to push for the end of H visas at the Department of Labor?
Senator, I appreciate the question. My discussion of the topic, as you say in that book chapter, was part of my ongoing attempts at contributing to the policy conversation on these issues. As I know you're aware, my role, if confirmed as Solicitor of Labor, is not a policymaking role. My role would be one of being one to help enforce the law and to keep the department within its legal bounds to the best of my abilities.
Well, but would you advocate? I mean, that's fine. And if so, if you are going to advocate, what would you suggest to the secretary? How would you fill these labor gaps?
Well, so, Senator, again, what I would say there is, again, first of all, this is primarily a policy conversation. Secondly, I think we are. I think there are obviously some ongoing conversations in this space, including we're seeing kind of in real time what the labor market effects are as, for example, the Trump administration has been enforcing our immigration laws, and so we're starting to see shifts in those labor markets, which I think need to be studied in order to understand. The last thing I did want to say about the policy proposals was it was not an advocacy for any sort of immediate cessation. These were supposed to be thoughtful, targeted, sort of capped and predictable phase downs over a lengthy period of time, and in the agriculture context, supported specifically by investments in agricultural production improvements and technology that can improve the productivity of American workers, productivity being the thing that allows greater wage growth.
I hear you. Mr. Rogers, in 2023, the Department of Labor leveled a $1.5 million civil penalty against Packer Sanitation Services, one of the largest food and sanitation service providers, after they found children were working with hazardous machines and cleaning dangerous powered equipment. In response to the Packer Sanitation case and additional reports, Senator Padilla and I both pressed the CEOs of 37 major companies who'd been accused of participating in exploitive child labor practices. And we pressed them. Our letter demanded that the companies take immediate steps to cease these practices. Obviously, Senator Hawley has been talking about child labor as well, and I couldn't agree with him more strongly. During the Biden administration, the Wage and Hour Division launched a National Child Labor Strategic Enforcement Initiative to prioritize investigations of the most egregious and exploitive child labor violations. So, Mr. Rogers, if confirmed, what's your plan at Wage and Hour to root out illegal child labor practices?
Thank you, Senator. And as I had responded to a previous question, I think following what the department has already begun, the Secretary has said she intends to double down on enforcement of child labor, and that is something that the Wage and Hour Division is something that will continue to do and use the resources that are available, the data that's available, to continue that important work.
I appreciate that. I'm out of time, but I will have other questions. Trust me, no one you'll all have a chance. I'll submit them in writing. I appreciate, again, your time coming here and your willingness to serve.
Senator Murkowski.
Thank you, Mr. Chair. And thank you to all of you for being here today and your willingness to serve. I want to begin my questions to you, Mr. Berry, and I appreciate the discussion that we had in my office. Project labor agreements, as I mentioned to you, prevailing wage, both issues that are important to the labor community in Alaska, and I think really provide incentives for Alaskans to go into the trades. Can you share with the committee your view on PLAs and the prevailing wage?
Absolutely, Senator, and I really appreciate your making the time previously to meet with me. I was very grateful for that. So I'm also thankful for the opportunity to clear up some confusion here, because in my labor chapter in Project 2025, I opted not to take a position. I think it's been common among Republicans and conservatives in particular to be very critical of Davis-Bacon. I chose to take a position of agnosticism and essentially of openness, and in fact was criticized by a dissenting view in that chapter for not taking the opportunity to go after the law. So I would be completely committed to enforcing that law in my relevant part as solicitor.
Thank you. Mr. Rogers, let me ask you, again, when we talked, had an opportunity to talk about the career opportunities that are available in the trades because of good wages, career options that are created by Davis-Bacon. Do you support prevailing wage?
Senator, as we discussed, thank you for that opportunity to have our conversation. I think it's important that the Wage and Hour Division continue to do its enforcement efforts with respect to Davis-Bacon, like all of its other statutes, and it's important to make sure that prevailing wages are being properly calculated and applied in ways that further and enhance the purpose of the Act.
And just then for follow-on, do you support the current method for calculating prevailing wages in a given area of the country?
Yes, it's important to make sure that we are doing those calculations based on appropriate data and that they are doing the work that the statute and Congress intended.
Very good, thank you. Let me turn to you, Mr. Esposito. Thank you for being before the committee. The Inspector General Act of 1978 states that inspectors general should be appointed, quote, without regard to political affiliation, close quote. It creates an expectation of independence and objectivity. So can you share with the committee how you feel an Inspector General ought to approach their job as it pertains to getting involved in partisan activities, and then what mechanisms you would put in place to not only protect you, but your office from real or perceived political pressures, or perhaps the perception of improper political influence?
Well, thank you very much for the question, Senator. And as I mentioned before, I look forward to, if confirmed, leading the Inspector General's Office of the Department of Labor without fear or favor. I've spent my entire adult life as a public servant, most of it being a New York City detective, sharing a car with members of my team, different color skin, different political background, certainly different economic backgrounds. My life depended on them, theirs on me. And you got out of the car every day to do the job. It didn't matter who the mayor of the city of New York was. It didn't matter who the police commissioner was. We took an oath, and I take that oath as I would here, and that is to root out waste, fraud, and abuse in the Department of Labor so that, and as I mentioned before, I know that there's been talk of reigning in the golden age of the American worker, and I don't believe that any of us should be perceived as being partisan by wanting to rein in that golden age. That should not be a Democrat or Republican issue. That should be an American issue. And I think the work that we need to do in the Inspector General's office is to make sure that the workforce, in order to receive fair wages, in order to be have safe work conditions, in order to eradicate child trafficking and exploitation in labor, we need to make sure that all those resources are dedicated. And if confirmed, I will, like I mentioned in my opening statement, travel to each of the regional offices and hear from the men and women on the ground to find out what is actually happening, what we can do better. And quite frankly, I think that they need to feel that they're heard and that they're believed in, and that would make it a more efficient and more productive Inspector General's office.
Well, and I appreciate what you've shared at the end. I think it is critically important that it be perceived that within the office, there is no political judgment, there is no political bias, and that people feel that they will be treated and judged fairly in all accounts. Thank you, Mr. Chairman.
Senator Kane.
Mr. Chair, and thanks to the witnesses. Congratulations on your nominations. First, Mr. Chair, I want to ask unanimous consent to enter into the record 4 letters from more than 80 organizations opposed to Mr. Berry's nomination and 4 letters from more than 60 organizations opposed to Commissioner Lucas's nomination.
Without objection.
Thank you. Commissioner Lucas, thank you for what you're doing in a situation that's sort of intolerable and that I believe is intolerable, serving as the chairman of a commission that's supposed to, by law, have 5 members and only has 2. And you don't have a quorum, and that's not your fault. But I do think there is fault in that, and I think there's an intentional strategy that I see happening in agencies established by Congress, and many are agencies where there are commissions or committees that are supposed to have a majority membership from the president's party and a minority membership from the party that is not in the White House. And that's to try to create some notion of balance, but also recognize that winning the White House confers the ability to have majority representation on these committees. But what I'm seeing my colleagues do, and the White House as well, is fire Democrats, as 2 were fired on the EEOC, not nominate people to have a quorum, or when they are nominated, not nominate the Democratic members. We have had a series of votes on the floor this week, not with respect to the EEOC, but other organizations like the FTC, where the tradition that has been honored by all Republican presidents and all Democratic presidents of having a full commission with a full quorum, with a majority from the president's party, that has been honored in this body for a very long time. But this year it's not being honored. And we're allowing the possibly illegal firing of members of commissions like the EEOC, and the administration is choosing to forward Republican nominees but not Democratic nominees. And my colleagues, instead of insisting, hey, look, the law is the law, fair is fair, it will be a Republican majority but not a Republican monopoly, are not acting to empower the commission. So you're doing what you can without a quorum, and I know that you've been asked plenty of questions about that, and you've also pointed out there are things that you can't do without a quorum, but that's on Congress or the administration. But I just want to let my colleagues and the greater American public know that these bodies are important. They do important work. I mean, you testify to the importance of your work in your written testimony as somebody who, in your childhood, you had the experience of seeing what it was like to have a parent who was discriminated against. These are agencies that are important, and an intentional effort to kneecap them by keeping them without a quorum or hyper-partisan them by refusing to nominate members of the minority party does a disservice to the important mission of each of these agencies. And I just wanted to bring that to everyone's attention. Again, that's not on you, that's on the president and on this body, which has the power under Article 1 to offer advice and consent on presidential nominations. Mr. Berry, I do have a question for you. I was made aware that during your interview with the Democratic staff of the committee, you stated that women want to work part-time when you were asked about engaging more women in the workforce, and apparently there were follow-up questions, and you sort of said the same thing. How many women in this room work full-time? Raise your hands if you're a woman who works full-time. Okay. I see a number of hands going up among the women in the room. Behind me and here, I'm seeing some over in the other room who are raising their hands. I mean, do you think that like part-time work is sort of more of a woman's thing?
Senator, I appreciate the chance to clarify that. That was in fact not what I said. What I said was that labor market surveys of various types, I was thinking of some recent ones by American Compass in particular, had revealed that a very substantial number of women in the workforce, or excuse me, just women in America, have a stated or revealed preference in favor of a greater amount of part-time or flexible work. That's sort of nothing more, nothing less. This was not a categorical statement about women at all. It was a survey-driven, data-driven observation.
So there are men who want to work part-time and men who want to work full-time, and there are women who want to work part-time and women who want to work full-time, and the opportunities that are available to men and women should be equal, correct?
100%, Senator.
And you would acknowledge, as somebody who's worked in this area professionally, that there are still significant barriers to women in the workplace, correct?
Yes.
Now, that puzzles me, though, because I understand in response to a question from Senator Baldwin earlier, and I might have gotten this wrong too, so you can correct, that you do support eliminating the Department of Labor's Women's Bureau. Is that correct?
So, Senator, what I said was that I support the president's decision in terms of the agenda that he chooses to put forward, but I've not personally advocated for that.
I'm over time. Thank you.
Thank you so much, Mr. Chair, and thank you so much to the witnesses for being here today. I just have a couple of questions. Those questions are for Mrs. Lucas, and I'm really happy to be able to ask a few questions today because in this administration's words, I really believe we need radical transparency when it comes to individuals who will be entrusted with enforcing civil rights protections. Now, your Twitter bio says that you are, and I quote, advancing colorblind equality. But in September of 2023, you voted against authorizing litigation against Tesla for racial discrimination. In that case, the commission alleges, and I realize that 3 of the 5 did eventually vote to advance that case to litigation. But it alleges that since 2015, Black employees at Tesla's Fremont manufacturing plant have routinely endured widespread, ongoing, and I would say egregious racial harassment. So I wonder if you can just tell us about your vote. Why did you vote against remedying this pervasive and unlawful hostile work environment?
Thank you for the question. While I can't answer your question directly because I can't breach confidentiality or deliberative privilege, I can say that I have voted for numerous cases involving egregious racial harassment that has been brought against workers of all races, Black, white, Asian, Hispanic. It doesn't matter who they are. No one should be judged by the color of their skin. I approach each litigation matter that we vote on based on the specific facts before us and the law as it applies. So that is the global way I approach everything. It's inherently
No, I'm not asking you to breach any privilege here. This was a public vote that was taken. I'm not asking you to comment on the litigation itself. I am just interested in what your own thoughts are that caused you to take that public vote. And I note that you have spoken about some of the other internal decisions, talking about which ones were unanimous, for example. So you have spoken out about some of what happened internally. So I'm not asking about the litigation. I'm asking about, in your own mind, your public vote that you were taking. Can you just explain what you used to make that decision?
Again, respectfully, Senator, I can acknowledge specific votes. I can acknowledge when I've made a dissent public. I can acknowledge if a vote count, but I cannot talk about the deliberative privilege that went into a particular decision to vote in a particular manner on a litigation matter.
I think it's interesting to call it deliberative privilege. I mean, it is what your mindset is regarding the information you heard. And in this case, a federal judge allowed that EEOC case to proceed, saying that the complaint had done more than enough to demonstrate the racial harassment at the plant, and the culture in this Tesla workplace was so hostile and so pervasive that Black workers at the plant were repeatedly being subjected to racial slurs, including the N-word, racist graffitis, cartoons, and even more offensive, nooses that were being hung throughout the factory. And this is one you voted against. And so the reason I'm asking this question is I am concerned about whether, if this doesn't rise to the level of a Title VII Civil Rights Act violation, I just wonder whether you can, explain to me, in your own mind, why didn't this rise to the level of a Title VII violation?
Again, respectfully, every litigation matter consists of presentations by career staff and the internal workings of the commission. I cannot reveal the information that was provided to us, the matters that we concluded, the factors that we bring. All of those things are protected by privilege. I can point to my voting record on behalf of any number of Black workers who I have been proud to vote in support of litigation filed on their behalf, including ones involving nooses, including slurs, including the use of the N-word. I have no bar against any of those fact patterns rising to it, but each case is inherently a fact-dependent, legally dependent matter.
Okay, so 2 more just quick questions on that then. Is it that you then commit here in this hearing not to deprioritize racial discrimination cases as chair? Is that what you would say? Would you say that you would be able to appropriately use Title VII in all cases of discrimination, including racial discrimination?
I am absolutely committed to combating race discrimination in every single form and have filed lawsuits and supported lawsuits on behalf of workers of every single race, Black, white, Asian, Hispanic, it doesn't matter. No one should be judged on basis of their skin color.
Okay, thank you. Just one final yes or no. I know that already you've moved the EEOC to dismiss some of its own lawsuits against employers. So then will you commit here today to continuing to litigate this case until its conclusion?
The decision about whether or not to pursue or continue any decision is something that we'll have to assess at each particular moment. I can't commit to continuing any particular case.
Even this very heinous Tesla case, you're saying?
Again, each case it will be fact dependent at the time.
Thank you.
I ask for enter several letters of support for the nominees into the record, and as chairman, I grant that consent. For any senator wishing to ask additional questions, questions for the records will be due at 5 p.m. Friday, June 20th. Thank you again for the nominees for being here. The committee stands adjourned.